Today is the 22nd of March, 2010, and in 1989, when I spoke in the Supreme Court of Canada in the Keegster case, I said that to uphold these hate laws would be a slippery slope, which would eventually come back to destroy free speech in Canada. It has. It's now beginning to destroy the universities of this country, where one would expect with adults, with the capacity to reason, with the free marketplace of ideas being of the utmost importance for the determination of learning and truth and education, you now find at the University of Ottawa, as I read the headline in the National Post today, "The University to Ann Coulter, please watch your mouth." That's the headline, but even a more condescending statement is made by the provost of the university, who tells her that restraint, respect, and consideration when speaking at the school are her primary objective and duty. And the student union, for what it's worth, will not allow her to post posters on the school property, and it's beginning to look more like a kindergarten than a university. These institutions have become centers of indoctrination in political correctness and left-wing ideology. That may be what the Supreme Court of Canada wanted, but I wonder if it's what they really foresaw. I put this entire controversy at the feet of the Supreme Court of Canada, who, being quite intelligent people, could have and should have foreseen this end result of the censorship of speech by law. There is no way to determine truth without hearing both sides. That's the fundamental principle of justice. Audi alterum partem. Hear both sides. And that means also hear all sides of every issue, historical and otherwise. And if we do not have this freedom in Canada, we should look to the Supreme Court for having taken it away. Of course, it was the Parliament of Canada that passed these hate laws, satisfying pressure groups and special interest groups, but it was the Supreme Court of Canada who, in the Keegster case and in the Taylor case, upheld laws of this kind in order to satisfy the same political pressure groups and interests. And they said it was demonstrably justifiable in a free and democratic society. Well, I say it is not. It is not, because we are intelligent, capable human beings, and we should be trusted with the capacity to hear and determine for ourselves, not determined by some policeman who may have half the education we do, who will decide whether to charge someone or not, and not decided by some screaming pressure group who decides they don't like to hear from Ann Coulter or someone else. I may not agree with Ann Coulter either, for that matter, in some ways, but what difference does it make? It's important to hear what someone has to say, and in the end, if the Supreme Court of Canada's judgment in Keegster and in Taylor continues to be applied the way it has been, then this country will be a place where there is really no significant speech at all. It will be a place of conformity, uniformity of opinion, and fundamentally stupidity. That will be the end result of the censorship process that's well underway at the University of Ottawa, and which will continue in other universities and other places of higher learning, with the ultimate elimination of the most significant aspect of human intellect, and that is the ability to decide for ourselves. If we can be trusted to vote, why can't we be trusted to hear the opinions of such controversial speakers as Ann Coulter, and even Mr. Galloway, who was also prohibited from coming to Canada and speaking? This country is becoming a real nanny state, and that's really why Western Canada needs to establish free speech here once and for all, and we can't do it in Canada because the Supreme Court of Canada has ruled that this type of restriction is the acceptable way in the Canadian political system.